As an attorney for over 15 years, I bring to you the New Legal Hour, where you will hear from top attorneys and judges in areas such as family law, personal injury, child support and custody, trademarks, probate, and so much more. Join us every Tuesday at 12 noon on Facebook Live or YouTube Live to get the answers to general legal questions that you may have. And don't forget to subscribe to our new legal YouTube channel at Attorney Tamika Johnson. And for more information about our firm services, visit johnsonlawpractice.com today.
Hello. Welcome, everyone. This is the Legal Hour, where every Tuesday at noon, we are joined by attorneys and judges and other legal professionals to talk about just different areas of law, giving you tips and resources and advice and just a little bit more perspective into their area of legal expertise. I am Tamika Johnson, your host. I am an estate planning attorney out in Georgia, specializing again in estate planning, wills, trusts, healthcare directives, power of attorneys, deeds, uncontested probates. For more information about my services, feel free to visit the website, johnsonlawpractice.com, schedule a consultation, and we'll get you going from there. So today I am excited about our guest, Attorney Page, out in the DFW area. I say Dallas-Fort Worth area.
Yeah.
She's going to be talking about bankruptcy. It's one of those subjects that a lot of us don't want to talk about, but it is necessary in some situations. As I put on the screen, bankruptcy, we're going to talk about the requirements of filing for bankruptcy, the relief that you get sometimes, emotional and financial when you file for bankruptcy and go through the whole process, and how to rebuild, because it is not the end of your story. It is a restart, from what I say. So I'm going to have Attorney Page introduce herself really quick. I'm going to get right into it. If you have any questions or comments, be sure to put it in the chat. I will be sure to ask Attorney Page those questions, and we will go from there. So with that, Attorney Page, thank you for joining us today.
Well, thank you for having me, Tamika. I'm Theda Page, and I am the owner and founder of the Page Law Firm in Frisco, Texas. And for those of you who are not familiar with the Dallas-Fort Worth area, Frisco is just due north of downtown Dallas. Just a straight ride up the North Dallas Tollway. Some people know Frisco because it's the home of the Star and the Dallas Cowboys. I'm not a Cowboy fan. I'm not a football fan, but I know lots of people are. And so they know Frisco for that reason. And I have been a solo practitioner for 20 years, focusing in the areas of bankruptcy and family law. And family law is kind of anti-family, as I call it, because it's about divorce and custody and child support and all those things that can make you cry. But bankruptcy, I like to say, #bankruptcy is beautiful because it can give you relief. It can put you on the trajectory for rebuilding your life. Bankruptcy is all about a fresh start. That's the whole purpose of bankruptcy. And bankruptcy's been around for a long time, going back to the late 1800s. So it's not a new phenomenon. It's been there for people, and it's something that people should not be afraid of. I call myself the Reconstructionist because that's what I do. I help people reconstruct and rebuild and start over. So happy to be here. Thanks for inviting me.
Of course, that's great. So, I have considerable experience in real estate and real estate closings. Okay. And what I tell people, the real estate market is very cyclical, right? Mm-hmm. Sometimes it's up, sometimes it's down. But I always tell people, when the real estate is down, that's when bankruptcies a lot of times go up, because just even in the current trend that we're in right now, with inflation and people having bought a lot of homes at really elevated prices, we're just like one check away or a job away from a lot of people losing their homes, just not being able to afford those things. And so I anticipate and see bankruptcies coming up in the near future. A lot of people have talked about getting a house within the last year or two. And I'm like, if you can hold off, because this market is going to change. They don't listen to me, but
must come down.
So yeah, real estate goes down, bankruptcies go up. So that's just, unfortunately the way it is. And probably in your
Mhm.
practice, when financially, when things go down, family law, divorces, those things go up as well. So
Mhm.
again, it's nothing to be ashamed of. But we're going to talk about just kind of the process. So let's just do like a 101, very basic. There are different types of bankruptcies. Tell
Yes.
us a little bit about the difference of the bankruptcies that there are and which ones you specialize in.
Okay, so there's the bankruptcy code has chapters, and so you might hear of chapter 7, chapter 11, chapter 13. Now we have a subchapter 5, which is kind of a hybrid between an 11 and a 13. Most individuals file either a 7 or a 13. When you think about chapter 11, individuals can file a chapter 11. But when you think about 11, you're thinking about General Motors, American Airlines. It can be for a small business too, but that's more of a reorganization for entities with a lot of debt.
Mhm.
So most people are looking at a 7 or a 13. A
Okay.
7 is sometimes called straight bankruptcy or a liquidation. And a chapter 13 is a reorganization. It's sometimes called the wage earner bankruptcy. And that's because you have to have disposable income, money left over at the end of the month, in order to be able to fund a plan to repay your creditors. As one of my clients years ago called it, I told him, I'm trying to calculate your disposable income. We're looking at your income, we're looking at your expenses, we want to know what's left over. He says, that's my beer money. Okay, that's your
Mhm.
disposable income, your beer money. We can budget for beer in bankruptcy. Not a lot, but we can have, it's a line item, entertainment. But we're
Yeah.
looking at what's your income, what's your expenses. Now, there's a formula that determines which chapter fits you. And in a chapter 7, most people think, well, I don't have enough money to pay my bills, so I must be a chapter 7. But there's actually a formula. We have to look at your income for the 6 months prior to the filing of your case and your household size. Bankruptcy is federal law, but obviously cost of living is a little different in Atlanta, the Dallas area versus a small town in Iowa. So there are different median family incomes for the different states, but we're still looking at what's your income, what's your household size. Then that determines whether or not you can qualify for a Chapter 7. Chapter 7 is my favorite because you're over and done with pretty quickly, about 90 to 100 days, and you're on your way to a fresh start. But Chapter 13 can be fabulous because if you bought that house and you lost your job, you got behind on mortgage payments, and your home is posted for foreclosure, you can file a Chapter 13, stop that foreclosure, and you have anywhere from 3 to 5 years to repay those payments that you missed. Maybe your wages are being garnished for income taxes or student loan debt. Not right now, student loan debt, it's kind of student loan debt's in this weird space right now. So the
Let's
payments
hope
have
it stays in that space for a minute. Okay.
we're all trying to speculate what's going to happen because those payments have been stopped because of COVID. So everybody's in like the holding zone for their student loans. But
Yeah.
student loans typically are not dischargeable in bankruptcy. So if those student loan payments resume, some people may not be able to pay their credit cards, pay their student loans, pay their mortgage, pay the car, keep the lights on, food on the table, clothes on the kids. So Chapter 13 might be a good option. Won't make the student loans go away, but it can help you with your cash flow and help
Mhm.
you get rid of some of that credit card debt or get current on your mortgage payments. And then you are on your way to rebuilding. So requirements are, we got to look at your income, your household size, certain allowable expenses. Allowable expenses include taxes, health insurance, things that are not dischargeable. And that can tell you which chapter. Is it 7 or is it 13? And you may need a 13 because you may be behind on what the bankruptcy calls domestic support obligations. 3 words: child support, alimony. So maybe your wages are being garnished for child support or alimony. That's not going to go away in a bankruptcy, but it can help you get that garnishment stopped if you have missed payments and that's why your wages are being garnished, and help you restructure that debt. So another good reason for Chapter 13. You can't get rid of that child support. So don't think I'm going to walk into bankruptcy, get rid of my child support. That's not happening. Kids need to eat. They need a roof over their heads. But it might be able to help you with some of your other debt. Get that restructured and get you on your way to some relief and rebuilding.
Right. So I'm going to give a couple scenarios just so people can kind of get a feel for maybe how someone can assist them in bankruptcy, or how bankruptcy would assist them. So basic scenario is, and I was telling you this before we came on, when I was 24, I filed for bankruptcy. I probably shouldn't have, but it was after my first year of law school. And I'd gotten pregnant, and I was just listening to my parents, and my father was like, you need to file bankruptcy. I didn't know why. I just kind of was like, okay. I had some credit card debt. I was in law school, so I didn't, my student loans weren't due at the time. But you know, and I was telling you, the attorney that I went to, I probably paid him more than what my debt was, because I didn't own a home. I didn't have any property. All I had was my car, and I did have a car note, my car, and student loan debt or credit card debt. So what would a person do in that situation? What chapter do you suggest with a person in that situation?
So if someone's 24 and they come to me, there's no debt requirement. Like, you don't have to have, say, $20,000 in credit card debt or $30,000 in credit card debt. But I'm going to talk to them about how much debt do you have, and is there a way you can pay this debt, rather than filing a bankruptcy. And I love bankruptcy. I think it's wonderful. I enjoy being able to help people get that fresh start, but it's not right for everybody. And at 24, in credit card debt, your student loan debt, that was going to be like your baby too. That's going to be with you. But the credit card debt, do you remember how much you had?
Back then, oh my gosh, it was like over 20 years ago, but I'm sure it was under $2,000. I'm sure. It totally, now that I'm looking at it, I was like, why did I file for bankruptcy? But I just think that at the time my parents didn't know any better. They were kind of like, we're not going to help you in this endeavor of having your child. We'll support you in other ways, but not financially. And I think they just knew that I had credit card debt. It just wasn't that much. In hindsight, I shouldn't have, but I did. And it was a blemish for 7 years, I think. Oh my God.
So here's the thing. If you are unsure about, should I file a bankruptcy, go talk to a bankruptcy lawyer. And the National Association of Consumer Bankruptcy Attorneys, NACBA.org website, has a map, has lawyers that you can go talk to. Most bankruptcy lawyers will I offer a complimentary strategy session, 40 minutes. We hop on Zoom and we talk. So talk to more than one. Get a feel for, do I like this person? Do they get me? Do they understand me? What are they doing to help me? I talked to a young woman last week on a Monday. I was the 10th bankruptcy lawyer she had interviewed. That's a lot. Wow. And it was only like 4 o'clock. So clearly she'd been busy all day long. But talk to more than one lawyer and get a feel for, is this right for me? Is this something I should do? And I always tell people, I can't tell you what to do. I can give you some advice and counsel and weigh the pros and cons. talk to the lawyer about what are the benefits of filing bankruptcy. Those are my pros. And literally get out a piece of paper, write it down. Or, if you're young, maybe use your phone in the notes app. But put down the pros and the cons. You said it was on your credit. It is going to be on your credit for 10 years from the date of discharge. However, it clearly didn't stop you. Here you are, young woman, younger than I am, but you got through law school, got your own practice, doing well. It didn't stop you from doing what you want to do. And I always joke and say, I know my clients are doing fine post-bankruptcy because a couple years after their bankruptcy is over, they'll reach back out and they'll say, I'm buying a house and I've lost all those papers that you told me to keep. So I need all those papers because I'm buying a house. So you can rebuild. It is not the end of the world, even though it's still on your credit. And depending on what your credit score is, the filing of a bankruptcy can improve your credit score.
Yeah, for sure. And so as an attorney, I did a couple different things within the first few years of me practicing. And so bankruptcy was one of those things. It just wasn't something I ended up doing long term. But what I can say, the process changed from the time that I started doing bankruptcies to how they're done now. And one of those things is the counseling, the pre-filing counseling. So can you talk a little bit about what that is, and does it have to be done before they come to you, when they come to you, or after it's filed?
Okay, so you need a ticket to get into bankruptcy. You need a ticket to get out. And the ticket is your credit counseling certificate. That's your ticket to get in. Your ticket to get out is your personal financial management course certificate. The pre-filing course takes about 90 minutes. And one of my clients told me she literally watched a movie on Netflix while she did the course. I tell my clients it's like eating your peas, and I don't like peas. So, you know how when your mother said you can't leave the table until you finished? That's what that course is. So you got to do it because your attorney has to have your completed certificate when they file your case. If you have not taken credit counseling before your case is filed, your case can be dismissed. And you have to start all over. There's a filing fee that you pay to the federal government for filing your case. You'd have to repay that filing fee. You may incur additional attorney's fees. Those courses cost about $20, $25. So you definitely need to get that course taken. And then in order to receive your discharge in bankruptcy, your discharge is the order that the bankruptcy judge signs that says you are no longer legally obligated to pay your unsecured non-priority obligations. I describe it as non-priority. That's how the bankruptcy code describes it, because student loans are a priority. A domestic support obligation is a priority. So that's not going away. But in order to get that discharge, you have to take that second class, the personal financial management course. And some of those personal financial management courses, I use a particular course provider. But most of my clients tell me that they find that course beneficial. The one that you take before your case is filed, they want to know what's your income, what's your expenses, how much debt do you have. And it's not anything where anyone's checking your work. You don't get a grade. The bankruptcy judge is not looking to see what your answers were. So it's nothing to stress over. Just get it down. Eat. I like eating your peas. If you need some orange juice to get it down, get it down. You need to watch a movie on Netflix while you're doing the class, do that. Just get it done.
Yeah, mix those peas and some mashed potatoes. Yeah.
Right.
Watch the Netflix movie.
Put some gravy on there and you're good.
Right. Okay, so let me give you another hypothetical. Let's say let's say they had like a $15,000 credit card bill or loan. Let's say it was a loan. They never paid, went into collections, and then they got sued for it. And then now the company has a judgment. And then one day they go into their bank account and they see like there is a hold on all of their funds. Every last penny of money that they have in all of their accounts is frozen. because there was a judgment and now they're trying to garnish your bank accounts. What do you do in a situation like that for clients? Do they have time to take that course? Can they wait afterwards, or how do they even get their funds released in that situation? Like, where's the light in that? Because you have food to get for your kids and daycare to pay.
So you have to act quickly.
Right.
So that's one reason why I tell people, if you get sued, please don't put your head in the sand. Please don't ignore it, because only bad things can happen, like you just described. You look at your bank account and it's like negative $83,000, and you're like, what in the world? What's going on? I didn't even have 83,000. How am I negative 83,000? And it's because there is a judgment creditor who has snatched your bank account. Now, you can get a bankruptcy filed fairly quickly. You can do an emergency bankruptcy filing. Still have to take that class. Like I said, that's an hour to 90 minutes. And then you can file an emergency. Now, every creditor will not automatically release those funds because of how assets are protected. So some creditors, I'm not naming names, but Wells Fargo, they're not going to release. So if you bank at Wells Fargo and you've been sued, you need to move with a quickness because they play hardball. Eventually, you can get your money released. Usually it's about 30 days after your first meeting of creditors. Now, some financial institutions will release the funds right away because you have filed a bankruptcy, but others want to be very careful that they are not releasing funds that really do belong to creditors. The bankruptcy code is federal, and we have federal exemptions, but some states do what's called an opt-out, which means federal exemptions are not available to you. And that's why a nationwide creditor is like, different laws, different states, got to be careful. I'm going to wait and get direction from the bankruptcy trustee before I release funds. So
that's interesting. So, okay, so you're saying once someone files bankruptcy and they have, I have this petition here, they go back to their financial institution to say that I filed bankruptcy and to release the funds. And you're saying some banks do, some banks don't, and Wells Fargo doesn't. Is that what you're saying?
That's exactly what I'm saying. And they're not going back to their financial institution. Their lawyer is contacting the financial institution.
Okay.
So people don't, you don't have to worry like little old me trying to negotiate with a nationwide creditor. That's why I hire a lawyer. My bankruptcy lawyer is going to contact the financial institution.
Okay. And you're saying even from that point, once you contact the financial institution, it still can take up to 30 days after your meeting of creditors, which is like several months, right? Because the meeting of creditors is like, 45? Okay. Things have changed. Go ahead.
So the first meeting of creditors, we'll get down in the weeds, can be no sooner than 21 days after your case is filed. So it's about a month after your case is filed. And like in our jurisdiction, they're held on Fridays. So I can just about guesstimate, like today is August 9th. I know that probably if I were to file a case today, that creditors meeting will probably be September 16th.
Gotcha.
Then, so 30 days from there is when Wells Fargo is turning over the money. So that's October.
Wow. That's a long time. Especially for people who have like their direct deposits or their their checks, automatically into their.
You contact HR or wherever and get that direct deposit stopped or moved to another financial institution so that you can get your money. But that's why, even though a lawyer can help you when you're in that situation, it's better to try to avoid that situation. Like the moment you've been served with a lawsuit, and credit card companies will sue you. I've heard people say, well, my dad told me Visa would never sue me. No, Visa will sue you. they have no qualms about suing you to collect their money. So
Right.
once you have been notified that a lawsuit has been filed, and you need to contact an attorney and figure out, do I need to fight this? You can't really fight the lawsuit if you owe the debt. You might be able to negotiate something, but do I need to participate in this litigation, or do I need to just walk to bankruptcy court and get it taken care of that way? And especially, say you've been sued by Citibank, Visa, and you have an American Express card and you have a Discover card, and you've got some significant debt, it may not be worth it to try to negotiate and settle when Citibank has sued you, because MasterCard, Visa, Discover, American Express, they're all coming to the party too. So why not take everybody to the bankruptcy court party? Take care of everything all at once.
Right.
Get your relief, rebuild. Get your fresh
Right.
start, get on your way.
Okay, so the next question would be, okay, so let's say a person has a lot of debt and they don't know exactly, who the creditors are. Maybe there's some collection agencies going from one person to another person. How does a person find out everyone that they owe to put into the bankruptcy?
Okay. So read your mail, whether it comes to your mailbox or your email inbox, read your mail. And answer your phone, because if you owe people, they're calling you. They're probably blowing up your phone. So answer your phone. Now, you don't necessarily want to talk to them. Debt collectors are not the nicest people in the world. They are not going to win the Mr. or Miss Kindness Award. What you should say to the debt collector is, hey, thanks for calling. I've just retained a bankruptcy lawyer. So you've said the magic B word.
Okay.
And my bankruptcy lawyer said she needs to know exactly how much I owe and what is the address for noticing purposes for bankruptcy.
There's a script. Did everyone get that? There's a script.
Yes, that's the official.
Use the B word. Use the kind of like the good B word.
That's the really good B word. So, I mean, I get it. I mean, these people are blowing your phone up. You don't want to talk to them. And that's why you got to start the conversation with the B word, because they don't know. Has this person already filed a bankruptcy? Because there's an automatic stay that is in place immediately upon the filing of a bankruptcy. And creditors have violated that stay if they continue to collect debt after you file. So that's why you got to get that B word in, so that makes them feel like, you've kind of turned the tables on them. Okay. So I need to listen to what this person is saying and make sure I'm not violating the automatic stay. So, and then the creditor is probably going to say, what's your case number? You haven't filed a bankruptcy yet, so you don't have a case number. It's like being pregnant. You are or you're not. You're in bankruptcy or you're not. There's no like, well, I'm on my way. Well, I'm making payments to my bankruptcy lawyer. That doesn't count. So that's why you have to tell them, I'm about to file. They can still attempt to collect until you file, but you definitely, that is one way to figure out who do you owe, because they're blowing up your phone if you owe money.
Okay.
And some things that creditors can do that people may not quite be aware of is they can call your mama and them. It's called skip tracing. They can't discuss the nature of the debt, but they can call those people. When you fill out the application and it's asking you about emergency contacts, it's not because they care. It's because they want to know who they can call if you don't pay the debt.
Right. Okay. So let's say a creditor has called someone. They actually filed, and your client, they told the creditor, I filed bankruptcy. I gave them a case number. And then they call you again. What happens? You said they're in violation. So what happens after that if they do that?
Rain at that point.
Okay.
I have had clients who have made money by filing bankruptcy.
Wow, really? Do explain. Do tell.
Because that creditor has violated the automatic stay, which they are not allowed to do.
Mm-hmm.
And I had one creditor, obviously I can't say the name, but my client was a recent widow. So her husband died kind of unexpectedly, and they had a lot of debt. She could not service this debt. So you can imagine you've lost your spouse. So you're grieving, and then you realize on top of that grief, I've got my house of cards is falling financially. So maybe you're talking to your kids, not sure what to do, and you end up filing a bankruptcy, which is what happened with my client. Her son reached out to me, can you help me help my mom? We get her into bankruptcy, and a particular creditor came to her house to repossess a vehicle after she had filed. That creditor used some pretty colorful language. Now, mind you, she's a recent widow, older woman, grieving, debt, having to file bankruptcy. And the creditor was not nice. So her son reached out to me. I wrote a demand letter to the creditor's counsel. I've never had to use such colorful language in a demand letter, but I was repeating what was said to her. Mm-hmm. So she got a free car and some money.
Really?
Yeah.
Wow. Is there a statutory amount that creditors have to pay, or?
No. There's not, like if you call twice, it's $10,000 or anything like that. So it's kind of, there are some lawyers who only specialize in stay violation work. That's all they do. Bankruptcy lawyers say, hey, my client, Miss Jones, filed her case. XYZ creditor is continuing to harass her. I'm going to send this to the stay violation attorney. So those attorneys who specialize in it, the creditors know exactly who they are. And as a lawyer, when you know who the players are, oh, Miss Johnson, she is not bluffing. We need to do what Miss Johnson says, because she will take us to court and sue us. So it's one of those nuanced things.
Okay.
Mainly, but
gotcha.
You can, I had another one where they kept sending emails to my client. He would respond, I'm in bankruptcy. Here's my case number. Here's my lawyer. And the next day he'd get another email attempting to collect the debt. So he made more money than he paid for his bankruptcy. So he got a discharge of all his debt, and he got a little bit of money.
Okay. That sounds promising. Okay. So let's talk about the items. I know you usually said it earlier. Items that cannot be charged in bankruptcy, although you may work out a payment plan, but what thing that, for the most part, can't be discharged?
So certain taxes, generally that's fairly recent tax obligations, like within the last 2 to 3 years, those tax obligations. And obviously I'm speaking very high level. This is governed by the bankruptcy code, the tax code. So lots of codes, lawyers writing words. So, but in order to discharge old tax debt, you have to have timely filed your tax returns. That doesn't mean you can't get an extension, but if the tax deadline is April 15th and you get an extension till October and you file by your extension deadline, that is a timely filed tax return. So timely filed tax returns, old tax debt, you can get that tax debt discharged. I always tell people, try to guess what my maximum I've ever gotten discharged for a client. So I'll ask you that question. What do you think is the largest tax debt I've been able to get discharged for a client?
I'm going to say 50,000.
120,000.
120. Wow.
Yeah.
Well, that's a lot of tax debt.
That's a lot of tax debt.
I just can't even imagine that much tax debt, but wow.
Yeah.
Okay.
So
And was that because it was an older, they were older tax debts and
older
you were able to
tax,
get them discharged?
and they had timely filed their return. So they filed their tax return and they owed money and they knew they couldn't pay, but they timely filed their return. So it's
Gotcha.
important to timely file your tax returns. That's whether you're filing bankruptcy or not, timely file your tax returns.
Right.
That debt may or may not be dischargeable. If the IRS is garnishing your wages and you file a bankruptcy, they have to stop that wage garnishment. Now, you may still owe that tax debt on the other side of your bankruptcy, but they have to stop garnishing your wages. So that gives you control over your money.
Mm-hmm.
Child support, not going away in a bankruptcy. And your domestic support obligee, the person you pay child support to, they're going to get a notice about your bankruptcy. That may be a little uncomfortable for some people, but they do have to be notified. And the bankruptcy trustee sends them a letter that says, Mr. Jones owes you for child support. Mr. Jones has filed bankruptcy, but Mr. Jones will still owe you the child support.
Okay. So let's say someone is paying child support and it usually comes out of their account check automatically. Does that continue even after the C is filed, or pause for a minute, sometimes like the tax debt?
That is going to continue because usually that is a voluntary wage garnishment. Voluntary in the sense that when you got an order for child support, you also signed up for the child support to be taken from your check. So even though your wages are garnished for child support, you've done that voluntarily, sort of voluntarily.
I know plenty of people where that child support garnishment was not voluntary at all. So they just kind of got found. It was taken out. But yeah, I just didn't know that if it continued or again there was a pause on that.
Mm-hmm.
So if someone, let's say that is the case, someone does have a child support obligation, do they even have to list it in the bankruptcy? Maybe they don't even want the other party knowing that they're going through this. They do have to list it.
They have to list it. It's not going away. And in order to get your discharge, you have to be current on your child support obligation.
Oh.
So maybe when you file your bankruptcy, you're a month or two behind on your child support. In order to get that discharge in bankruptcy, you have to be current on your child support.
Okay.
And then in Chapter 13, that reorganization, you have to sign a declaration saying, I am current on my child support. And you're signing a declaration under penalty of perjury of law. So you don't want to lie to the federal government about your child support.
Right.
Because that comes with some penalties.
Yeah, I believe it. Let's talk student loans. It can be discharged or not. Now, I don't say this authority because I had touched bankruptcy in many years, but I used to hear that there was a difference between getting your private loans discharged versus your federal loans. Case or explain what that process is as far as student loans, the pause, and all of that.
So there's a case that determines that's kind of the standard for the discharge of student loan debt. And it's pretty hard to meet that standard. And so that's why people say the student loans are not dischargeable. And if you want to try to discharge your student loan debt, you have to file what's called an adversary proceeding, which is a lawsuit within your bankruptcy case in order to try to discharge that debt. That is also, like I talked about, like stay violation lawyers. There are student loan lawyers who do that in the context of a bankruptcy. I'm not one of those people. If I see somebody who it's like, oh man, I don't know, maybe can you get your student loan discharged? I'm going to refer you to an expert in that area to have your facts and circumstances analyzed to see, is there a possibility? Because pretty much public, private, hybrid, they're not going away.
Okay.
Maybe if you paid your
And
tuition on a credit card.
yeah. Yeah.
And
I can
there's
see that. Okay.
there's also case law that talks about, did you really use the proceeds of those loans for educational purposes? And there's a carve out for if you didn't use it for educational purposes. Here again, I send people to the student loan experts to look at that analysis. I started doing bankruptcy work. Well, that was many years ago, like before the current bankruptcy laws were enacted. And I've been a solo practitioner for the past 20 years. I've never had a client get student loans discharged.
Wow. Okay.
I've
Good
only
to know.
referred maybe 2 or 3 people in 20 years to the student loan expert.
Oh, you've only referred 2 or 3, you said?
Yeah.
Wow. Okay. Is there anything else that can't be discharged as far as maybe certain types of judgments that you get?
Fraudulent debt.
Okay.
And fraud is a pretty high standard. So your average consumer isn't going to have fraudulent debt. Now, there's a presumption that if you've used your credit card, what we'll call it on the eve of the filing of a bankruptcy for non-luxury goods or services. So that doesn't mean I'm buying groceries and diapers at Walmart. If you're at Neiman Marcus buying Louis Vuitton and you don't tell your bankruptcy lawyer and you put this Louis Vuitton on your credit card and then turn around and file a bankruptcy, in all likelihood, your bankruptcy lawyer is going to get an email or a phone call from the credit card company saying, did you know that your client spent $5,000 at Neiman Marcus 30 days before their bankruptcy was filed? And probably the lawyer's going to say, no, I didn't know that. Well, I like to look at my clients' credit card statements before I file their case. And I tell them, once you have consulted with a bankruptcy lawyer, don't use your credit card. Because every time you use your credit card, you are saying, I promise to pay, just like I never filed, So if you're saying, I promise to pay, and then you turn around and file a bankruptcy because you've consulted with a bankruptcy lawyer, when you signed, I promise to pay, were you really promising to pay when you just talked to the bankruptcy lawyer the day before? So if you talk to a bankruptcy lawyer, stop using your credit cards. And don't use your credit card to pay your bankruptcy lawyer. Use your debit card. Use your mama's credit card, your daddy's credit card, your sister's, somebody else's credit card, but not your credit card to pay your bankruptcy lawyer.
Now, what is the time frame in that? You said you gave a number of 30 days, maybe a person splurging 30 days in filing for bankruptcy, but is that the time requirement of doing something that's kind of extravagant, or is there a certain period of time, or no?
I think it's 60 days. I'd have to look in the bankruptcy code and tell you. Yeah. The number got reduced. But I think it's 60 days.
Did it?
And then there's a different number for cash advances on credit cards. So,
gotcha. Yeah, I've heard of people who have gone out and purchased cars or going on trips and just had some work done, maybe cosmetic work done, and then with the intent of filing for bankruptcy. Later on, which is so immoral and unethical, but I know people do it. But if someone calls them on it, I guess that could be considered fraudulent. and have an impact on their bankruptcy case. Is that correct?
Right. So,
Okay.
in terms of buying a car, that is different from using a credit card, because a car is there, they have a lien on that car. So the car can be repossessed if you don't pay. If you're using a credit card, they don't have a lien, so they can't repossess the Louis Vuitton you just bought at Neiman Marcus. Okay, so I had to look up the number. It's $500 for luxury goods or services. So we know if you're buying a Louis Vuitton, you've spent more than $500. $750 for a cash advance, and that's within 70 days.
Wow.
But most bankruptcy lawyers they're telling you, I want to see your credit card statements, because we're trying to analyze, what's your risk in terms of going into bankruptcy. Now, most people file bankruptcy way after. And it's not because they are intentionally, like what you just referenced, it's not because they're intentionally running up debt. Most people don't want to file a bankruptcy. They feel a lot of shame associated with having to do it, because they feel like, I have failed because I haven't been able to pay my debt. And I always tell people, when you walk into my space, you're walking into the no shame, no judgment zone. We're not going to beat ourselves up about what happened in the past. It happened. Most people are filing a bankruptcy because they've had a job loss, they've had a divorce, they've had some type of medical crisis, which has upended something that has upended their budget, a spouse dying. So most people are not strategically planning. We call it loading up on their credit cards with the intention of filing a bankruptcy. It just, that by and large, that's not what is happening with people. And most of my clients, they don't have enough open to buy on their credit card to do that kind of thing. I mean, they've been using their credit cards for living expenses. They've maxed themselves out. Then they've tried to work out payment plans with the creditors. Maybe they have been sued. There's not a judgment against them, but they have been sued. And that's when they really say, okay, I've got to figure out, how do I get out from where I am? And that's usually the bankruptcy lawyer is the last person they call. People will liquidate 401ks to pay debt. They will get a home equity loan to pay debt. Neither of those things do I recommend. Filing a bankruptcy is a much better option for you than liquidating your retirement, because you may be 40 and thinking, I don't need that money, but there's a time value of money. And when you're 65 and 70, you will regret that decision. Whereas if you file a bankruptcy, discharge that debt, you have preserved your retirement asset, which is a protected asset in bankruptcy. So don't take a loan against your 401k and say, well, I'm just going to pay myself back. Don't do that. Protect that asset. And there's a reason why that asset is protected, so that you will have those funds available in your old age when you need them.
That's great advice. I know, just still kind of doing closings, especially real estate closings and refinances for people who are paying off debt, because the values are so high right now. And I see a lot of people just kind of paying off that debt, which I think is a good alternative. If they're not struggling, they're not behind, but kind of gives them a restart as well. But yeah, I definitely can see those people who are trying to look at every possible means to pay off this debt so they don't have to file bankruptcy. And usually it doesn't work because you're still in that situation. So that's great advice as far as not liquidating your 401ks, retirement accounts.
I always say, if I could put a billboard up on every freeway, it would be, do not liquidate your retirement to pay credit card debt. I mean, let's face it, the these companies that you owe the money to, like the CEOs, they make a lot of money. Those companies will be okay if you don't pay your $10,000
Yeah.
to Discover. Discover is not going down because you didn't pay them $10,000.
Right. Right. Okay. So you have filed your counseling, you've done your counseling before you file. You have filed your petition and you with all your creditors. What is the next step after that?
So your first meeting of creditors comes about 30 days
Okay.
after.
And so what is that like? People, go ahead.
So it's kind of a misnomer. It's called the first meeting of creditors. Well, there's not a second meeting or a third meeting or a fourth meeting.
Okay.
And your creditors typically don't come. So that meeting, and in most jurisdictions, as a result of COVID, those meetings are held via Zoom or telephonic. In my jurisdiction, that's the Eastern District of Texas, they're telephonic. So I tell people you can be at home in your fuzzy slippers with your Dr. Pepper, your cup of coffee. I don't recommend that you have an alcoholic beverage, but your beverage of choice. And you wait on the line until your case is called. And then that meeting lasts about 3 to 5 minutes. The hardest question you're going to get asked probably is, what's your name? You are going to have to say, like, what caused your bankruptcy filing. Now, they do not need you to regurgitate your life history. I lost my job is a sufficient answer. I lost my job, period. No need to explain. I worked for the company for 10 years and I got laid off. I've been looking. I lost my job. That is sufficient. Then the attorney, the bankruptcy attorney, is asking their client a series of questions. Did we meet? Did we talk about options available in bankruptcy? Did we discuss that this particular option is best for you? Did I give you some paperwork to fill out, a homework package? Did we meet again? Did you sign documents? Do those documents list all of your assets? Do they list all of your liabilities? Is there anyone you could sue in order to get any money to pay your debt? That's about it. The bankruptcy trustee may have a couple of questions for you. One of the reasons why, when you're looking for a bankruptcy lawyer, you want to hire an experienced bankruptcy attorney, because you want to be sure that everything is in order prior to the filing of your case, and that the bankruptcy trustee knows who your lawyer is, knows that your lawyer has a reputation for doing good work. So then they know that, okay, things are in order. The bankruptcy trustee's job is to see, are there any assets available that can be used for the benefit of creditors? This is in the context of a Chapter 7 bankruptcy. And at 13, you have a first meeting of creditors. Here again, there typically isn't a second, third, fourth meeting. Creditors aren't there. But because you are in a repayment plan in a Chapter 13, that meeting might last 15 or 20 minutes, because the Chapter 13 trustee wants to be sure that you understand all the requirements of being in a Chapter 13, like making your payments on time, continuing to pay your mortgage or your car if you are paying those outside of your bankruptcy, paying those directly to the creditor. The Chapter 13 trustee is going to have some policies and procedures that they want you to understand that are in place. So that meeting's going to last a little bit longer. Hopefully, by the time you've gotten to that meeting, you have already taken your second class. If you are in a Chapter 7, you are going to have to sign a document called a reaffirmation agreement if you plan to keep your car. And you're going to keep making your payments on your car just like you never filed a bankruptcy. But other than that, after that creditors meeting and you've done your reaffirmation, you're taking your class, you're good to go. And then your discharge order comes about 61 days after your first meeting of creditors. So that's why I say a Chapter 7 is done about 90 to 100 days from the date your case is filed.
Okay. So question, if you have a Chapter 13 and it's more of a reorganization or repayment plan, should I say, who is the debtor making the payment to? Are they making it to their attorney? Are they making it to each individual? Or is it going to the trustee? Who are they paying?
Okay, so it's kind of like being in a debt management program, only it's not a scam. A lot of debt management programs are scams. I mean, frankly, a lot of people come to me because they've been scammed by a debt management program. They've been making the payments and their creditors don't get paid. They get sued. They lost their money. So a Chapter 13, and there could be good debt management programs out there. I don't know about them because people come to a lawyer typically when they have a problem. So if it works, they don't need a lawyer. If it doesn't work, that's when they need a lawyer. So there's a Chapter 13 trustee called the standing Chapter 13 trustee. Why they call them standing, I don't know. I mean, do they stand versus sit down? I don't know. But they're the standing Chapter 13 trustee. And that person is a dispersing agent. So you make the monthly payment to your trustee, and then your trustee pays creditors. The creditor, you propose a plan, you tell the trustee, here's my plan. And the trustee follows your plan once the bankruptcy judge has signed the order confirming or approving your plan. So you say, I am 12 months behind on my mortgage. I want the bankruptcy trustee to pay those back payments. And there's a formula that determines how much your unsecured creditors, your credit card people are going to get. So I'm paying the bankruptcy trustee $400 a month. The bankruptcy trustee does not do this out of the goodness of his or her own heart. They're running a business, so they get a cut, about 10%. You pay $400, $40 goes to the bankruptcy trustee. That means you have $360 left over that's going to your creditors. In most instances, some of that money is going to pay your attorney's fees. Maybe you make a down payment to your attorney and they get the rest of their money through the payments that go to the Chapter 13 trustee. So $400, $40 goes to the trustee, $360 goes to your creditors. If you're paying mortgage arrears, so the back payments on your mortgage, those payments get paid before your credit card payments get paid because they are a secured creditor, so they have protection. So those arrears are going to get paid. So maybe for 3 years, you're paying legal fees, mortgage arrears. Then the last 2 years of your 5-year plan, you are paying on your unsecured debt. And if your creditors do not file claims, they don't get paid. So you may have $70,000 in unsecured debt. And the formula says you got to pay $70,000 to your unsecured creditors, but they don't file claims. As long as you complete your plan, you get a discharge and they don't get paid, but you have received a discharge.
Gotcha. Okay.
So it's
Good
really
stuff.
important that you complete your Chapter 13.
Right. Good stuff, Attorney Page. We're about at an hour. So now it's time to go back to lunch or work or whatever it is, wherever it is you have to go. Do you have any just kind of parting words for anyone who is kind of like on the fence right now, has a lot of maybe medical debt, again, debt, someone lost a job, first steps to take, and just overall, just about the bankruptcy process?
Absolutely. You should reach out to a bankruptcy lawyer. And so, I mean, if you're in another state and you're watching this and you reach out to me and you say, hey, I'm in Iowa. Do you know a bankruptcy lawyer in Iowa? I can't, off the top of my head, I can't think of a bankruptcy lawyer in Iowa, but I can probably point you in the direction of how to find a bankruptcy lawyer in Iowa. Like I said, National Association of Consumer Bankruptcy Attorneys. I mean, read people's website. See if there's something there that, kind of like, oh, I think this person gets me. See, are they on the internet? Do they have a YouTube channel? Watch their videos, look at their Google reviews, see what people say about them, reach out. And as I said earlier, most bankruptcy lawyers are not going to charge you for a consultation. So talk to them and get the information, write down your pros and cons. Here are the benefits of filing a bankruptcy. Here are maybe the not so good aspects of filing a bankruptcy.
Right. All right. Thank you so much for coming on. I do have Attorney Page's website scrolling at the bottom of the screen. That's going to be the Page Law Firm. Let me not see the. It's www.pagelawfirm.com. You can reach her there. Thank you for joining us. We will see you again next week. We'll be talking about long-term care planning and final expense insurance and that kind of thing, because it is so important that we handle those things as well. We will see you all next week. Share this video, like it, pass on the information to family and loved ones, and just make sure, again, you remember that bankruptcy is not the walk of shame, but it is a lot of times just that reset that we need financially, emotionally, and mentally. Thank you again for joining us, Attorney Page. And we'll see you guys next time. All right. Bye-bye.
Bye.